For being here
This
on time.
meeting is being recorded.
For those of you who don't know me, I'm Michelle Lindgren. I'm with Western Resources Title, and I love being part of the board. Been a title rep for more than half my life, and I live here in Palos Verdes Estates, and I love just being a resource. So when I find a good resource, I like to share it. I've worked with Alan for years, and he just knows a lot of timely information. So I brought him, and then he suggested that we bring Charles in, who's a lawyer. So a quick background on them, and then I'll hand it over to them. For those of you who don't know Alan Rigg, he has been 32 years as an engineer working through the many processes of the cities of Palos Verdes. 14 of those years, he worked as the Planning and Public Works Director in PVE. He saw over 1,200, no, yeah, no, about 1,200 meetings over 300 planning commissions. And he's been a consultant to RPV for 21 years. So he's a professional engineer and a certified planner. But mainly what he does is he helps people navigate this PV city process. And today he's going to dive deeper into that. And he's brought along a coworker that he works with, Charles Peterson, who is another PV resident. He's lived here for 35 years. And he was the chairman of the PV Park Committee. He's a lawyer that really helps people with neighborhood disputes, deciphering zoning and local ordinances, and helping you and your clients protect your views. So I will hand it over to them. Please mute yourself. It looks like you guys are all muted. And save your questions for the end so that they can do their complete presentation. But we did save time at the end to answer your questions. So jot them down or put them in the chat, and we will make sure that those are all answered, and they can stay as long as you want after to answer your questions. So with that, I'm going to hand it over to Alan, and thanks for being here today.
Thank you, and good morning, everybody. Michelle, you got my screen okay there?
Yes, looks good.
Okay. Good morning, everybody. So we're going to talk about 3 different processes in the city of Palos Verdes Estates regarding your views. The first one, Charles is going to take over in a minute here for Resolution 191, which is an evolving target. I'm going to talk about other ways to get views from vegetation, both on private property and then on public property. Views are important, and they can add a lot of value to you and your clients. As Michelle said, at the end, we'll have questions. Michelle will also send out this PDF, so you don't have to take pictures of the screen like I've seen people do in the past. So she'll send that out. Also, it's being recorded. She'll give people a link to that. And like on the other ones I've done, each slide is just, I don't like to just read slides, and I don't think that's the value. I'm going to put something up on the screen each time, and then talk about it like Charles will do. And hopefully you get a lot of value out of this. All 3 processes are changing, but with that said, Charles Peterson will speak about Resolution 191, and this covers both Palos Verdes Estates and also part of Miralles, but mainly is implemented in Palos Verdes Estates. Charles?
Thank you, Alan. Good morning. Before diving into the details of the current rules, I thought I would give you a smidgen of history. California became a state back in 1850s. Most of the law that existed at that time was English common law. That included a doctrine called the Doctrine of Ancient Lights. The Doctrine of Ancient Lights came from England, and it protected views, sunlight, and airflow. Property owners were entitled to their views under English law. In 1870, in a case in San Diego, the California Supreme Court said, no, we are not going to allow the Doctrine of Ancient Lights to continue. In California, people can block anybody's views anytime and prevent sunlight and airflow. In the ensuing 150 years, the rules have evolved to the point now where the general rule stays the same, that views are not protected, but if your city or your county or your homes association gives you that right in ordinance or by CC&Rs, then you can move through that process and restore your views. The Palos Verdes Homes Association has been struggling with this issue of views and trees since at least the year 2000, when they first did a resolution, Resolution 146, which was their first attempt to give the Homes Association members the right to restore views. We're now up to Resolution 191. They've given it about 15 or 20 tries at tweaking this resolution. Resolution 191 was enacted in 2021, and as you can see, the purpose here is to establish view protection guidelines and provide a way for members to get their views back and preserve the views that they once had. So, next slide. The authority of the association comes from the CC&Rs. It's Article 5 that gives the association the right to go onto members' properties to trim or remove trees that, in the opinion of the association, are too high and obstruct other people's views. The CC&Rs do give the members the right to go to court when they believe that their views have been unreasonably obstructed. Just as a side note, all of the cities on the Palos Verdes Peninsula do have rules. The other 3 cities have view ordinances. Palos Verdes Estates gives the jurisdiction for these disputes to the Homes Association. Just as a historical anomaly, the Homes Association came first, 1923. The city came second in 1939, and the city didn't want this responsibility, so it remained with the Homes Association. Next. Resolution 191 has definitions to guide members and the courts and the juries. Scenic views are defined, the main viewing areas are defined, what constitutes significant view obstruction is defined in Resolution 191. 10 or 15% of the value of properties, in my experience, are related to views. If you have a view property, 10 or 15% of the value of that property is due to the view. The most I've seen was in Malibu, where the appraiser set the value at 22% of the value of the property. So it's important that cities and associations in view areas have these rules to protect these views, not only the financial and economic value of the views, but also the emotional and psychological value is very important. I've had clients sell their homes before Torrance put in the Hillside Overlay District, maybe 10 years ago now. People could not get their views back. They have some great views over in that area, and I had 2 clients move because they weren't able to get the views that they once had, and they felt like they were trapped. And so it's a miserable thing to lose a view, and it's a great thing that the cities on the peninsula realize that and have these rules that allow residents and property owners to preserve and restore these views. Also, there are many articles written in the real estate industry and academic articles that place that discuss the value of views. So, next slide. Resolution 191 does lay out the criteria for the not only the courts but the members to evaluate whether or not their views are legally restorable. Most of these cases do settle, by the way. One neighbor will go next door and say, "Can I trim your trees?" And the neighbor says, "Sure." And they have a nice bottle of wine and it settles. I would say very few go to court, but it's gotten very expensive to go to court now, and working these things out, evaluate whether or not it's worth it to you to actually go through the process. Next slide. Under Resolution 191, the Homes Association requires that the property owners talk first and try to resolve this privately without moving on. The next step, next slide, is mediation. If the informal discussion process breaks down, bad chemistry, history between the neighbors, they don't like each other, you've got to offer the neighbor, the tree owner, mediation. Importantly, as you could see there, the association's role is very limited. In the past, the association's lawyer would take on these cases and bring them to court. That's no longer the case as of Resolution 191. Now it's up to the members to enforce their rights. The HOA was encountering a lot of problems taking these cases to trial prior to 2020, and the expenses got not bearable for the HOA. So the burden now is on the property owners to get their rights restored. Next slide. Yeah, as a last resort, if mediation fails or is not accepted, the view seeker can go to court, and it's a long and drawn out process now. From the time that a complaint is filed in the Torrance Court or downtown, probably at least 18 months if to get to a jury trial if it doesn't settle. Probably longer, 2 years. The court congestion is an issue now. If you do go to trial, the jury or the judge will determine whether the views are obstructed using the criteria laid out in Resolution 191, and that documentation would be the judgment is sent to the HOA. It's a binding decision, but it can be appealed from the trial court up to the appellate level. We haven't had any cases go to the Supreme Court just yet. Next. Resolution 191 does provide how the costs are to be allocated from mediation, and then the court will allocate the litigation costs through the memorandum of costs after judgment is entered. The goal of Resolution 191 is to let people know that they should think twice before going to court with these disputes. They do get very emotional. People do get quite motivated to get a resolution one way or another. if the neighbor does not, if the tree owner does not comply, why court is the last resort. Next. This is the process we've just discussed, the initial discussion, and through mediation, and then through litigation. Mediation is a good way to get these resolved. From 2005 to 2016, I mediated 85 disputes for the PV Homes Association, and 5 of them went to court. So 80 of them resolved amicably between the neighbors. A lot of what drives that is that these people have to live together, and they're oftentimes next door neighbors or nearby neighbors, and people don't want to be living with a fight going on every day. So mediation is a good way to get this done. Next. Resolution 191 does set forth the preference of the association to not remove trees as a first resort, but to trim, crown reduce, thin out the stand of trees before removing them. PV does try to protect trees, as you know. The city just did an inventory, and apparently there's over 20,000 trees, city trees in PV estates, and they do like the trees as well as the views. So there's a tension that creates disputes, and this is the process for handling those disputes. Next. This slide references the case that I just had in downtown Los Angeles. It was a 8-day trial that took almost a year for the judge to give us time in the court to resolve this. The decision was firstly that Resolution 191 was a legal process, that the tree owner did challenge Resolution 191 as improper, illegal, not within the HOA's authority. The judge said, no, it's perfectly fine. The other issue that came up was whether the homes had to be adjacent to one another for Resolution 191 to apply. And the court said, no, views can get blocked whether they're half a mile or a mile away. Attorney's fees, the decision on that is going to be made Thursday, tomorrow. I'll be in court to argue that my client should recover the attorney's fees. There is a provision in Resolution 191 regarding that. Next. And so that's my presentation on Resolution 191. If you do have any questions, let me know. Alan?
Yeah, thank you, Charlie. I think one thing that's important to know, if you do go through the 191 process, is if you do end up in court, it's very, very particular that you followed all the rules, that people are served at the right location, and all the timing's done right. So it's good to get somebody like Charlie involved that knows the process, because you can go through it and lose in the end. What I'm going to talk about is I haven't talked about this before in my different realtor talks. It's something that I've won on a couple times lately, and it's regarding private vegetation also in Palos Verdes estates. So what we've been able to find is, and what happens over time is, especially with neighbor compatibility, is that the Planning Commission will take a look at new homes and additions and structures that block views. And what they'll try to do many times is they try to offset those view impacts that are from homes, from structures, with a reduction in the allowable amount of vegetation that's on the site. In fact, this afternoon I'll be out at a house on Palos, Paseo de Mar, in which we're negotiating with the neighbor to limit the vegetation on the house in order to allow our brand new house to get built. So what happens is, and these get forgotten a lot, and we had 2 cases lately in which I was able to find that there were past approvals, in particular for neighbor compatibility, in which vegetation is specifically limited either by a condition of approval or by what's shown specifically on site plans. And that's, you got to look both places, because sometimes, unbeknownst to even the owners that have the project, the architect will put a limitation on vegetation on the plan, 5 to 8 feet, something of that nature. And so it's important, if you do have a view dispute, especially somebody buys a house, and these type of things get forgotten over time, is if there is an issue with views, and it is with a newer home, in particular, take a look through the files, the address files, take a look at the resolutions, and there is an active court case actually on a home down in Chelsea, in which we brought up the fact that they put a very specific limit on their vegetation, and they exceeded it. It was 6 to 8 feet, and they've got 22-foot tall ficus, and we're going to win, because that's what was agreed to in the beginning. So it's variation. It's not likely, but it's very possible that if you have a client that has an impacted view with vegetation, is to research the house that has the vegetation to see if the city at some point in the past has precluded the vegetation. The research also is important for 191. If you go through that process, a lot of times what will happen at the Homes Association, they put similar limits on vegetation on heights, or a common note which will say that if the vegetation becomes an impact of use, it has to be trimmed. But as Charlie indicated, they've totally abdicated their responsibility and say, go arbitrate, mediate, litigate. We don't want to know anything about it except for what you're doing, and we're not going to make any judgments. But what I'll talk about to complement the restoration of views on private property is the restoration of views on public property. And the city, Palos Verdes Estates, has a parklands committee, and they're good about this. And I've had a lot of decisions decided by them. I think I've had 13 in a row decided in favor of removing trees, and it's a good process. So what you need to do is, if you have a client or yourself is impacted by a tree on public property, and I want to clarify that public property, as far as this is concerned, really is right of way. I have only seen one application in 25 years be approved for removal of trees on parklands, and that was only because the golf club wanted to expand their parking lot. But nobody else has gotten one approved that I'm aware of. So what happens is you do an application through the Parklands Committee, and you go ahead and put forth your reasons, your photos, your application of the impacted views. And the Parklands Committee will review the application based on what's called the tree management policy. The tree management policy was developed 25 years or so ago, and it's patterned after neighbor compatibility. And what it says is you take a look at impacts to views, privacy, neighborhood character, and natural amenities, and that's how the Parklands Committee makes their recommendation. And I say specifically recommendation because the City Council will take eventual and final action on each of their recommendations. They'll take a look at the severity of the view impact, the condition of the tree. Usually, if nobody's opposed to the tree being removed, they'll get approved. There's a concept in the city coined by a former council member of restoring our aging urban forest, meaning that we've got a lot of very old trees in PV estates. Many were planted at the same time. The Grove in Belmonte, they're all going to die at the same time or close to it. And so this is an opportunity for the city to have an older tree that nobody really wants removed and replaced with a better tree that's respectful of views, will be younger, and will be of a variety that isn't going to have damage to infrastructure. If you have an application that goes to the Parklands Committee, they're particularly sensitive to damage to infrastructure, not so much to sewers, because the rationale is that a root will not get into a sewer that's not leaking. It's only a sewer that is leaking, so it's the remedy is to fix the sewer. But if there's lifted asphalt, sidewalks, curb and gutter, and exposes the city to a safety risk, they pretty much go along with any of those and will approve those. And then, as Charlie mentioned earlier, as within almost all these processes, if you're getting your view restored, excuse me, you're paying for all the tree removals and all the costs. So that's the same thing in the Parklands Committee. This was an application up on, this is on Via de Monte? No, Via Zarita. And so 2 trees, obviously view impacts. The neighbor adjacent to these on the other side of the street fought hard. You can be across the street. There is no limit to how far you can be away from the impacted, the trees that impact your view. These were across the street. We won, and just magnificent view afterwards. Another application, similar to what was not similar, it's identical to what I said before. You can see the flagging for the new home in the background. It impacted the neighbors' views across the street, allegedly, although they weren't that much. So we volunteered to go into the Parklands Committee and asked for the removal of this tree, and this showed the amount of ocean view we expected to get back above the new home. One thing, if you go to the Parklands Committee, the Parklands Committee can only approve what you ask for or less. So if you ask for a crown reduction on a tree, they can't approve a removal. But if you ask for a removal, they can do a crown reduction. In this case, we got the tree removed. Some points just to touch upon here. You can read these. Maybe they trigger some questions. But one of the things that I wanted to make sure that we bring up, and especially important in Rancho PV, and similarly important in Palos Verdes Estates, is when a picture of the view before the vegetation impacts it, incredibly important. And I would say whenever your clients buy a new home, have them take pictures because it's going to show what they had. In Rancho PV, it allows you into a very expedited process. At PV Estates, it will help you as well if you have to go to court and with your negotiations. And as Charlie said, the cooperation between neighbors, so many times, people just don't even know their neighbors, who they are. And so they start to fight, and if it can get calmed down, everybody wins. And again, if you go through, especially the Parklands process, there's strength in numbers. If 4 or 5 people are having their views impacted by vegetation, go together, they'll listen to those numbers and the like. With that said, I'm going to stop talking. I will leave this up for a second and then head it back to Michelle for a little question and answer session. Michelle, you're muted.
Unmute myself. Okay, let me go to the chat here because definitely some questions came in. So the first question was, what recourse does one have when the RPV agrees to top a pine tree on city property, but say that it's not prudent to trim it more than a few feet, as that may harm the tree? However, the trimming they agreed to does not restore the view.
Charlie, you want to take that one?
Well, it would depend on whether it was a private tree or a city tree. If it was a city tree,
It does say city property on a pine tree on city property.
very little recourse against the city for those type of decisions.
Yeah, I have to agree. The ones that I've done in RPV, they're pretty generous as far as removals. If they've got damaged infrastructure, the pines that like to lift up asphalt, curbs and the like, I think your best recourse would be to, if there is damage to infrastructure, to bring that up as a liability. The cities here, a lot of liability, trip and fall, they want to avoid a lot of those. So I would try to attack it again with a damaged infrastructure if there is any.
Okay. Also, what was the average cost of those 85 mediations that Charles has done? What's the average cost of a mediation?
Well, when I did those, the Homes Association paid for my time. It was basically pro bono that I did that for the HOA. They covered my costs. The residents did not pay anything. That program has ended. And now, if you choose mediation under the Resolution 191, you need to hire a private mediator. There are 4 or 5 very well established companies, JAMS, ARC, ADR Services, that provide mediators. They can be quite expensive now, $12,000 to $15,000 a day is the top end for these type disputes, down to perhaps $3,500 a day, split between the parties. For the mediator, if you bring lawyers, of course, you will be paying your lawyer's fees as well.
Okay, thank you. Another question was, how can we find out if a neighbor's house has these restrictions set? In this case, a new neighbor was planting in PVE, and other neighbors contacted the home association, who came to the property and reported that they were not planting trees that would impact views. Not many views were impacted, and the 2 houses on each side are dark in their lower areas. When asked to trim, the new neighbor said no. So how did the neighbors find out if their house has these restrictions set?
Well, all homes in PV estates belong to the association and are subject to the association rules. So it's just a matter of whether the trees fit the criteria for view obstruction. And the one thing I wanted to mention was that if you have clients that purchase a home in PV estates in a view area, the first thing you want to do is establish the view with photographs and bring those photographs to the HOA. Tell them to put them in the property file so that your view is on record for your new home that's purchased in Palos Verdes Estates. But yeah, the rules apply to every home.
Okay, Cheryl and Joe, were those questions answered? Did you have any follow-up questions that you want to unmute yourself and ask regarding your 2 questions?
Yeah, this is Cheryl. Can we call the HOA and ask if, because it's the people across the street from me, we had a nice view from our living room, and then as they were planting, I had the guy from the HOA come out and take a look at the property, and he said, no, they're not going to impact views. Everything's fine. And when I talked to the neighbor about it, I said, thank you. You know, we're really enjoying our view. Please don't impact it. And she told me, don't get used to it. That's now her new nickname in the neighborhood, but that's a separate subject. So now also they've grown so many thick trees that the neighbors on either side, who are both kind of private and shy, they're downstairs. They had mold actually in one of the houses because it's so dark, but they're afraid to talk to these new people that aren't very nice. Do I just contact the Homes Association?
Well, Cheryl, the Home Association has abdicated their responsibilities here. Under Resolution 191, the burden has shifted to the property owners themselves. The HOA should not be giving any opinions as to view obstruction now. And if you think your views are obstructed or will be obstructed, the best route is to speak to someone like Alan or an attorney.
Okay, thank you.
Yep.
Okay, hold on. I saw another question just come in. Does PVGC have any obligations to restore views for a RPV resident?
I'll start to take that one, Charlotte, because I'll split the baby on this one. I know there's a lot of trees that are on the public right-of-way. The trees on the public right-of-way and technically on the golf course would be subject to the Parklands Committee because they're on the parklands. So under the city's rules, it doesn't distinguish, and I had that on my slide, I didn't mention it. The PV Parklands process is open to RPB residents, Rolling Hills Estates residents, anybody. It doesn't matter where they live. It's because the impact is from the trees on city public property. And I'm gonna venture into the next one and make sure that Charlie corrects me if I'm wrong. Is that as far as the homeowners association process, the way the deed restrictions are written is it's the right to a property owner in Palos Verdes Estates to not have their views unduly impacted. So an RPV resident would not be able to avail themselves of the 191 process.
Mm-hmm.
Awesome. Thank you, guys. Does anyone else have any questions that they'd like to ask? They can put in the chat or they can unmute themselves and just ask directly.
Yeah, so this is Joe. Back to that question about topping that pine tree that's on city property. So if the view is, and this resolution 191 is for PV estates, right? But there's something similar, I'm assuming, for RPV, correct?
They have a view ordinance.
So if there's a view ordinance and the views are supposed to be protected, even if the resident is willing to pay for the tree to be cut down, if topping it by more than a certain amount of feet would potentially kill it, which there's different opinions on that. Well, I mean, can they say no if you're willing to pay for it? If the view is supposed to be paramount?
The view ordinance does not apply to city-owned trees, only privately owned trees. There's a different process in RPV for city-owned trees. The city makes the decision as to how much will be trimmed and how much will be topped, and it becomes a negotiation between the city and the resident.
It really is a gray area. I've had a couple applications, and you basically just email Public Works Department and say, hey, I've got a tree in my view, and they'll go take a look at it, but there are no specific guidelines that I've ever seen that regulates those. So it is kind of a no man's land or very gray as far as what can be done.
Yeah. Palos Verdes Estates has their Parklands Committee to deal with view obstructions being caused by city-owned trees. Rancho Palos Verdes does not have a similar process.
You're muted, Joe. Joe, you're muted.
Oh, sorry. All right. So in general, regardless of the city, are you finding that these new high fire rules, the density and the things that they're looking to do with distance from homes of trees and things like that, how are you finding that may impact things moving forward with trees being removed for insurance purposes and things like that?
Yeah, good question. Alan, you want to respond?
Yeah, I will. So it's very interesting the way the LA County Fire Department administers their vegetation restrictions in the city. The main thing they'll do is what's called a fuel modification plan, which is if you have an expansion of a home or a new home, they'll come in and they'll greatly regulate where vegetation can or can't be planted. The frustrating thing is they don't enforce that one bit. So I've got clients that have supposed to be no ficus hedges except for 50 feet away from a property, and it's right up against the home and in the view, so they don't regulate that. As far as they're very loose as far as the what they'll require for going out to homes and seeing where vegetation is. I was recently in our PV actually on a case in which we had the forestry unit come out. We had Italian cypress 6 feet from a building, which are definitely a fire hazard, and they wouldn't touch them, although they were creating a view impact and the like. I know there's also notices that come out and they'll do individual inspections of properties. The one thing that happened not too long ago, originally, when the very high fire hazard severity zones were implemented on the peninsula, gotta have the 2004, so they were kind of spread all over the place. In the cities, we all asked the county to go ahead and just make the whole peninsula a very high fire hazard severity zone because it didn't make sense. The one house on one side of the street was restricted and the house on the other side of the street wasn't. About 8 months or so ago, the state mandated that those original or close to the original restrictions be re-implemented. So much of the cities on the hill are now not in very high fire hazard severity zones. So it's been a back and forth issue. But as far as getting trees removed or anything for views in regards to the fire department, they're really no help. Even if they approved a plan, they very specifically precluded high vegetation in certain view areas.
Thank you. Okay. Soraya has a couple questions. I'll hand it over to her.
Okay, hi. I don't know if you can hear me, but thank you for having me. I have several questions because I live on Via Estudio. And Via Estudio has multiple problems with obstruction of views. Number one, they had, what I understand is that every street has a designated tree. And on our street, it's the eucalyptus tree. And many of them have been removed either because of storms or whatever. And then in front of my house, I happen to have 2 of the remaining trees. So I wonder what my recourse is because one of them is near the water main and it has become really, really big. So that's one question. The other question is Via Studio is near a parkland that has these pine trees that were planted as a Eagle Scout project. And now it has become this massive forest that is obstructing my view and the view of all my neighbors. 3, we also have the trees that have been really growing so fast from the grounds of PVHA'S, the middle school. And I know pretty soon we will have 0 ocean view left, not counting, trees from another residence on Via Cornell that have grown. It looks like really like a forest. And so we are wondering, there's multiple people on our street who have grown discouraged by what we can and cannot do to restore our views.
So Charlie,
Sure.
I'll take the first 2. So the eucalyptus in your right of way in front of your house, that's a Parklands Committee application.
Okay.
High likelihood of getting approved. The pines on the parklands, that's also a Parklands Committee application. Low chance of getting approved unless there's something special. Who knows who planted all the trees in the parklands? But that would be a tougher one. And then PVHA'S, I would let Charlie take that.
Thank you so much.
School districts are historically hard to work with in these situations. I have not had a school district be flexible in these situations. Very difficult to work with. They don't have a process for restoring neighbors' views. And Peninsula School District does not is not helpful in this regard. That's all I can say, because they don't have a process for handling these type issues.
Okay. Well, thank you.
Okay. Another question from Jane. My client lives across the street from the PV golf course, and she has an RPV address. Her view's been blocked by the golf course trees. Does she have any recourse?
Well, as I indicated earlier, I would say that those technically fall into the Parklands Committee, because the golf course is city property. And so she could make an application to the Parklands Committee to have those trimmed, removed, or whatever. But it's tough. The Parklands, the city has, over the last 10 years after the Lugliani case, doesn't want anybody to touch parklands ever. And even if it's on the golf course, but that'd be a tough one, but you could go to the Parklands Committee. One thing I wanted to mention, it came to mind when you're talking about the Estadio, as I negotiated a case over there. If you do go through these processes, and let's say you go through private property and you negotiate something with your neighbor, make sure to go to the Homes Association and get a permit to actually remove those trees. There's been some big fines. There was a big one over on Via Campesina where trees were negotiated to be removed. They were removed, and the Homes Association found out and levied a $20,000 fine. So on private property, when you're removing trees, make sure you get a proper permit.
Thank you very much.
She said she has another client that lives on Via Cerritos, and when they moved in, there was a beautiful view out the back of the property. Neighbors planted pine trees, and now the view is completely obstructed.
Call Charlie.
Yeah, that's Resolution 191. The resolution is on the Homes Association website. You can take a look and follow the informal discussion step by contacting the neighbor. If that doesn't work, you must send a certified letter to the neighbor requesting that they engage in mediation with you about the view obstruction. And then hopefully it will work out and resolve, and the trees will get trimmed through amicable resolution. But if not, then the next step would be litigation.
Michelle, possibly when you send out the PDF of our presentation, I had sent you Resolution 191 as well. Maybe would help the group if they had a copy of that.
Sure, I'll send that out so you guys will all have a copy of 191, and it will have Alan and Charles' contact information, because they're a great source that are available for you. So unless there's any other questions, I appreciate you guys staying over a little bit today. I feel like you gave a lot of great valuable information. I really appreciate you being here today.
Thank you.
So much.
Thank you.
Michelle.
Thank you.
Thanks, guys.
Thank you.